Hello, good morning, students. Please subscribe the channel, drop a like, share, and comment. This is Shree Vishnu Art Press Publications, exercise number 9 and 10 on the speed of 90 words per minute. Start. The allegation against the fourth respondent made is that a manipulation has been made in the revenue records and the insertion of the word servery has been made fraudulently in a different ink which is recorded in the remarks column in the said records. Sri Misra has then invited the attention of the court to the antecedent records to contend that this manipulation could not be made in all the revenue records, either in the parental family caste status of the fourth respondent or in the family where she has been married. The revenue records have been filed along with the writ petition to substantiate the aforesaid submission. It is urged that on the strength of a manipulation in the record of rights of 1331 fastly that the caste certificate has been obtained by the respondent number 4 on the strength whereof she contested the election as a backward class candidate. Accordingly, the respondent number 4, having taken recourse to such fraudulent practice, which is established on record, an appropriate writ should be issued for declaring her elections to be a nullity. Sri Misra has relied on 10 judgments, including several of the Supreme Court, to urge that a petition would be maintainable for declaring such election as a nullity on the ground so raised. He has further invited the attention of the court to 3 judgments to urge that fraud vitiates all solemn proceedings, and in this context the constitutional bar under Article 243K would not apply so as to relegate the petitioner to file an election petition. Responding to the aforesaid submissions, learned counsel for the State Election Commission has cited the decision of Lakhpati versus State of UP passed in W.P. number 5121 of 2016, contending that the nature of dispute raised herein is also a matter that would raise questions of evidence and which cannot be gone into under Article 226 of the Constitution of India. Learned counsel for the respondent number 4 has also urged that the inquiry with regard to the alleged manipulation in the revenue records cannot be made the basis for raising a challenge, inasmuch as the elections have been contested on the basis of a caste certificate, and in respect thereof a complaint was made before the issuing authority, namely the Tehsildar, who has submitted a report on 13/3/2016 before the district magistrate, urging that the said report be considered as the complaints with regard to the caste certificate are not true. The aforesaid recommendation has been made under the government orders that have been enforced for conducting an inquiry into the status of a caste certificate where the district level screening committee is chaired by the district magistrate. He submits that so long as the caste certificate stands, the election of the respondent number 4 cannot be annulled, as she has contested the elections not only on the basis of the entries in the revenue records but on the strength of a caste certificate that was issued by the competent authority after making full inquiry. Now, we may deal with another aspect of this very facet of the case. It is a very pertinent issue as to what the role of the state should be after the affiliation is granted by the affiliating body. We have already discussed that the state opinion, as contemplated under Section 37 of the University Act, to the extent it admits to overreach, is reconcilable, and its results are not in its orientation to the directives of NCTE are void and inoperative to the extent they can be resolved, in which case clear precedence is to be given to the directives of NCTE during such resolution. The opinion of the state, therefore, has to be read and construed to mean that it would keep the factors determined by NCTE intact and then examine the matter for grant of affiliation. The role of the state government is minimized at this stage, which, in fact, is a second stage. It should primarily be for the university to determine the grant or refusal of affiliation, and role of the state should be the bare minimum, non-interfering and non-infringing. It is on record, and the regulations framed under the Act clearly show that upon receiving an application for recommendation, NCTE shall send a copy of the application with its letter inviting recommendations or comments of the state government on all aspects within a period of 30 days. To such application, the state is expected to respond with its complete comments within a period of 60 days. In other words, the opinion of the state on all matters that may concern it in any of the specified fields is called for. This is the stage where the state and its department should play a vital role. They must take all precautions to offer proper comments supported by due reasoning. Once these comments are sent and the state government gives its opinion, which is considered by NCTE and examined in conjunction with the report of the experts, it may grant or refuse recognition. Once it grants recognition, then such grant attains supremacy vis-a-vis the state government as well as the affiliating body. Normally, these questions cannot be re-agitated at the time of grant of affiliation. Once the university conducts inspection in terms of its statutes or act without offending the provisions of the act and conditions of recognition, then the opinion of the state government at the second stage is a mere formality unless there was a drastic and unacceptable mistake or the entire process was vitiated by fraud or there was patently imminent danger to the life of the students working in the school because of non compliance with a substantive condition imposed by either of the bodies. In the normal circumstances, the role of the state is a very formal one, and the state is not expected to obstruct the commencement of admission process and academic courses once recognition is granted and affiliation is found to be acceptable.